everyone, and welcome to today's session titled The Practical Impact of Schrems II on International Data Flow. We're going to start because we like to be sharp on time in Consulegis, and I think the time now will say some welcome words. People will join now. It is a pleasure to have you all with us today. My name is Carys Thompson, and I am the Managing Director of Consulegis. It is great to see many young faces and some, or I would say many new ones as well. For those who don't know Consulegis, let me tell you a little bit about Consulegis. Is a leading international network of law firms and other advisory firms, such as tax and accounting, IP and M&A firms, as well as in-house consults that offers its members and their clients, among others, effective and personalized opportunities to collaborate and grow. Consulegis makes the world wordless, and we work on building unique, close and professional and priceless relationships globally. Our members are great legal experts who want to make better their clients globally. I encourage you to visit our website, consulegis.com, and to stay tuned for upcoming webinars or any others, or maybe to also to get to know our experts to all the groups that we have. And don't hesitate to contact us or any of them if you're interested in exploring opportunities for collaboration. Going back to our webinar today, we're recording the session, and the recorded version will be available for all attendees. If you want to share it with any colleague, feel free to share it. I am going to kindly ask you to put your microphones on mute to avoid background noises, although you have already done it. There will be a section of Q&As at the end of the session. We recommend you to type your question in the chat, or at the end to click on the raise hand option if you like to speak. Obviously, we will ask you to, if you ask a question by raising the hand, to keep it short. We hope this session will be lively. And now let's start today's webinar with our 7 experts in data protection from 7 different countries around the world. They are Bart van den Brande from Serious Legal in Belgium, Carys Thompson from Keebles in the UK, Connor Robinson from Lavelle in Ireland, Janak Bhatia from Bhatia Legal in India, Juris Boris from Marksman Advocaten in the Netherlands, Catherine A. Lewis from Meister Selling and Fine in New York, USA, and Dr. Johannes Strock from Brother Manchan in Germany. They will explore the practical impact of the so-called Schrems II about data transfers in Europe, which has dramatically altered the state of international flows. I would say, as a curiosity, only bear in mind that according to a report from the European Commission, the European data economy is expected to amount up to 827 billion by 2025. And the ability to transfer data across borders will be crucial for the recovery of European economy and probably for others after the COVID crisis. The Schrems saga is one of the most controversial transatlantic examples of different approaches of the personal data. And now I would like to start and hand over the floor to our moderator, Dr. Johannes Strock, one of the partners of our member firm based in Hamburg, Brother Manchan. Please, Johannes.
Thank you, Caroline, and welcome from my side. Thanks for joining everybody today. Well, last summer, the European Court of Justice published, let's say, a landmark decision on international data transfer, which affects almost every one of us. And the problem with this decision is that the court defined new requirements of data transfer, but without really saying how to meet them. So a lot of companies are really struggling how to comply with these requirements. And since then, at the latest, the name Schrems stands for legal uncertainty in international data transfer. So, but let's start from the very beginning, because Schrems has quite some history, and let's start with Connor. What is this all about, and what actually happened?
Hi, Jonas. Thanks for that, and thank you, Catherine. Next slide, and the next. So, Schrems II. Oh, back one. Thanks. So, Schrems II. So good they named it twice. That's slightly flippant, but it's quite accurate as well, because this is the second time Max Schrems has been down this route, and basically, this case refers to the international transfer of EU residents' personal data to a third country. So what we're going to do is we're going to start off by giving you a little background of where we were to get to where we are now. So next slide. So data exporting or exporting sounds straightforward, right? And why is it relevant to you? Well, as Johannes just touched on there, we are all affected by international data transfers. There is the Internet of Things, the World Wide Web, data centers dotted all over the world. Everybody's data is whizzing backwards and forwards at a phenomenal rate. And as Caroline said, it's only going one way, it's exploding. And the clash here has been what Europe wants to do in protecting people's personal data and what the rest of the world think about that. And Europe has been exerting its influence. So next slide. So history of data transfer. So we could go back to the 70s, and there was a wave of international or national data transfer laws or data protection laws in Europe. And that led to the OECD coming up with some guidelines, and the Council of Europe also coming up with guidelines. But none of them were had to be followed, right? It was only when the Data Protection Directive from the EU came in October 1995 that things got serious. And the key thing they're talking about here is the safe transfer of people's data. So the first thing that between America and Europe, which was where a lot of the transfers of data are coming from and still is, but the EU Commission and the American authorities came up with the Safe Harbor initiative, right? However, that was all blown out of the water to some extent with the surveillance spying revelations by Mr. Snowden, who was a former, if you don't know about him, he was a former NSA analyst who decided that the world should know what the Americans were up to in this mass surveillance. So Max Schrems, who was a law student in Austria at the time, decided he was going to take a case against Facebook's transfer of his data to the United States. However, the Irish Data Protection Commissioner refused to take the case because there was an adequacy decision in the form of the Safe Harbor rules. So a court case was brought in the Irish High Court. A preliminary reference was made to the CJEU, and the CJEU agreed with Mr. Schrems and said, no, just because there is an adequacy decision in the form of Safe Harbor, we can and will look at this, and they struck down the Safe Harbor. So we then got Schrems II, which was in reaction to the thing that replaced them, which was the Privacy Shield. And then, of course, what we have looming in the background now as well is that Brexit has happened, and the UK has now become a third country, and with no adequacy decision as of yet. The next slide. So just brief details on Schrems 1. So he challenged Facebook's reliance on the US-EU Safe Harbor framework as the legal basis for personal data transfers. And with the revelations of Snowden, the High Court in Ireland referred the case to the CJEU. And in 2015, the CJEU ruled that the US-EU Safe Harbor framework was invalid. This led, as we said, to them scrambling, and both sides were very keen to keep the data transfer flowing, and a new model was put in place, the Privacy Shield. However, next slide. Mad Max strikes again, because the new system that was put in place, the Privacy Shield, he and his advisors felt that this wasn't much better than the previous. And my colleagues are going to go into all the reasons as to why they are. So I'm going to hand over now to my next colleague, Joris, who's going to take up the story. Thank you.
Thank you, Connor. Yeah, it really seems that history repeats by this second Schrems II decision, and somehow it's nothing new, but on the other hand, everything is totally different. So, Joris, could you give us some brief insights onto the Schrems II decision and what's it really about? What are the new requirements now?
Yes, thank you, Johannes, and thank you, Connor. Good afternoon from the Netherlands. So after the introduction of Connor, we can draw a timeline, as you can see on the slide. After Schrems I in 2016, the US and the EU adopted the Privacy Shield. It's the successor of the Safe Harbor framework. However, in 2020, there's the Schrems II court ruling, and we can go to the next slide. And before I elaborate about the Schrems II court ruling, it's important to know the legal basis of data processing outside the EEA, the European Economic Area. In Chapter 5 of the GDPR, there are 4 conditions on the basis of which personal data may be processed outside the EEA. And you can see them on the slide. It's if a country is listed adequate, if there are appropriate safeguards in place, if there are binding corporate rules, and if there are other specific exceptions. Now, why do I mention these 4 conditions? Because the Schrems II court ruling mainly applies to 2 of them, which you can see in the next slide. First of all, the Schrems II court ruling concerns the validity of the Privacy Shield. And the Privacy Shield was declared invalid in Schrems of the Safe Harbor was declared invalid in Schrems I, and the Privacy Shield is the successor of Safe Harbor. And the court ruling and the Privacy Shield is actually for the United States, the adequacy decision which was given to them from the European Commission. So it provides a legal basis to transfer the personal data outside the EEA to the US and otherwise, of course. And second, the Schrems II court ruling concerns the validity of the SCCs, the standard contractual clauses. The contractual clauses are drawn up also by the European Commission. And by using these model clauses, controllers and processors can relatively easily achieve appropriate safeguards. Well, at least on paper. In practice, most of the time, these SCCs were concluded by a scribble, and that's it. And now we come to the Schrems II court ruling. The facts are quite the same as mentioned by Connor in Schrems I. It started as a complaint from Max Schrems at the Irish Data Protection Committee about data transferring from Facebook to the US. And simply said, Facebook justified the data transfer by means of the Privacy Shield and the SCCs, the standard contractual clauses. So the main question in Schrems II was, do these SCCs and the Privacy Shield offer a sufficient level of protection of personal data that is processed in the US? Then the answer is in the next slide. Well, short, no. The Privacy Shield was declared invalid, and the US could not be seen as an adequate country. So why did the court declare the Privacy Shield invalid? It's mainly because 2 reasons. The US has legislation such as FISA, which is a Foreign Intelligence Surveillance Act, which allows US public authorities to access personal data in certain situations. And access that is not limited to what is strictly necessary and proportional as required by EU law. And second, the court mentioned that EU individuals lack legal protection and do not have the right to an effective remedy in the US with regard to access of US public authorities. The court also addressed the use of the SCCs, the standard contractual clauses. As described on the slides, the SCCs remain valid, only it's not enough to just sign them. The court stated that it requires companies and regulators to conduct case-by-case analysis to determine whether the protection against governmental access to the personal data meets the EU standards. And if it doesn't, then parties will have to implement additional safeguards or suspend transfers. So to wrap it up, why does this court ruling have such a big impact? First of all, because the privacy shield cannot be used anymore by companies. And second, because the additional terms the court have set for the use of SCCs applies not only to data processing in the US, but to all non-adequate third countries. So as a business owner in Europe or anywhere else in the world, it has a lot of consequences, and my colleague Bart will take it from here.
Thank you, Joris. Question is how to deal with these requirements as a company in the EU, and so let's have a look on the practical side. Bart, could you give us some insight in that?
I'll try to do so, Johannes. Thank you. Good afternoon from Belgium. It's always very interesting to hear lawyers discuss legal topics and decisions by the European Court of Justice. But the real question for a business owner or a manager is always, should I be worried about this? And how should I react to this? Well, the answer to the first question is pretty clear. Yes, you should be worried about this. As Johannes has already explained to us, there is a direct impact by the Schrems II decision on data transfers between the EU and the US. Since the privacy shield fell, US-based companies will have to look for another legal basis. But the second part of that decision, the second part of the Schrems II decision will have as a consequence that all other data transfers to all other countries between the EU and the rest of the world are also impacted. And as Joris explained, we will have to look for a decent legal basis, which will in most cases be standard contract clauses, and potentially additional safeguards. I will come to that in a few seconds, but why should you be worried? The answer to that is very simple, because all throughout the EU, data protection authorities are starting to investigate the data export from the EU to third-party countries. Everybody uses Google, Microsoft, Facebook, Mailchimp, Azure. Every company within the EU uses mostly American-based software tools, or as Janek will explain afterwards, works with offshore software developers, often based in countries like India. We should all worry because the most striking example is the one you see at the bottom of the screen, where the Bavarian Data Protection Authority decided 2 weeks ago that they decided to forbid a Bavarian company, a German company, to make further use of Mailchimp, because according to the Bavarian authorities, the way that company was using Mailchimp was not in compliance with the Schrems II decision. Now, this does not necessarily mean that all companies in the EU have to abandon Mailchimp and abandon all other American tools.
Bart, your mic is switched off.
Bart, you're muted.
That is strange because I did not touch any buttons. Very weird. Anyway, what was I saying? The fact that the Bavarian DPA forbade the Bavarian company to make further use of Mailchimp does not mean that Mailchimp in itself or any other American software as a whole is from one day forbidden within the EU. But what we have to do within the EU is make an assessment, and you really have to get started with that, because if you do not follow the guidelines as they follow from the Bavarian DPA or from other DPAs, and I will not go into detail with other examples, but other DPAs throughout the EU, you will run into fines. And I don't have to explain, some of you may have seen this morning that Clubhouse, for instance, may have a data breach at hand that involves 1.3 million users' data. If an American software company has a data breach in the future where your data is compromised in the EU and in the US, and it turns out that you did not take sufficient safeguards to protect your data, you will have a problem. So what should you be doing as a company to prepare and to prevent running into risks? That is something that we'll look into on the next slide. Please. If you are an EU-based data controller, owner of the data, what should you be doing to protect your data in a sufficient manner today? How should you start reacting? Well, the first thing to do, and that is also on the next slide, the first thing to do is start making an inventory, start making a list of all the third parties that you are sharing data with, of all the data that you are sharing with them, the reasons why you are sharing that data with them, the sensibility of that data, make an inventory, assess also the necessity to send that data outside of the EU, because the first and basic guideline should be, if you do not need to export data, then don't export it, choose European alternative. Once you have an inventory of all the data you are sharing with third parties outside of the EU, do a vendor assessment. Try to evaluate the risk involved in that particular data export. Verify if they have a sufficient legal basis. That used to be Privacy Shield for the US. It will now have to be standard contract clauses or binding corporate rules. For all non-US based third parties, it will have to be standard contract clauses or binding corporate rules if you're part of a group of companies. But bear in mind, and that is the most important part that I want to explain today, that standard contract clauses in themselves are not enough to allow you, by definition, to export data outside of the EU. What you will have to do is try to evaluate if any additional safeguards are needed. That is what you will see in the green button on the slide, the need to demand additional safeguards. The contractual promise that your data is safe outside the EU is not sufficient. What you have to do is look for additional safeguards. We have guidance on that by the European Data Protection Board on the next slide. They have tried to explain to us on the next slides. They have tried to explain to us what or under which circumstances you can or cannot export data outside of the EU. A link to that guidance of the European Data Protection Board is in the bottom of the slide. What they have done is they have set out in a document of, I think, 30 or 40 pages, a whole series of examples of when you situations in which you can export data, and a whole set of examples of situations in which you cannot export data. The basic guideline that always comes back is the need to encrypt your data. That's what you'll see in the black button. State-of-the-art encryption. Try to make sure that the data that you are exporting outside of the EU cannot be accessed technically by any third party outside of the EU. Now, what is important is that the European Data Protection Board expects you as a company to encrypt that data independently from the encryption that is already offered by American or Russian or Chinese or whatever non-European platforms. You will have to make sure that the encryption takes place in the EU independently from the platform itself. Now, that is not always possible. The example of Mailchimp, you can't encrypt your database of mail contacts before uploading them to Mailchimp. That is impossible, but you can take a whole series of other precautions that are more of a contractual nature. That's what you'll see in the blue buttons, contractual guarantees in which, for instance, a receiving party in the US or in India or in Russia will promise that they will refuse any third-party access requests, or that they will contact you immediately in case of such a request, or that they will transfer all requests directly to you. That in itself can help you give or get a minimum level of security. Those are two examples of measures that you can take. You'll see in the European Data Protection Board guidance document that there are a number of others, but those are the two most important. The most important thing for you to do, as I said before, is get started with a vendor assessment. Try to get a grip of the situation, try to understand who's getting access to your data. If you want to do so, and that is on the next slide, what might be perhaps useful, there's a QR code here. We've tried to establish a data exchange vendor assessment form that you can download from our website, and that can be sent out to receiving parties outside of the EU, in which we'll try to get them to answer a series of questions that will help you understand to what extent your data is at risk outside of the EU, and it will help you take the appropriate measures, be it technical, contractual, organizational, but you will have to make sure that you take appropriate action. Again, and in summary, the result of the Schrems II decision is not that as a European company we can no longer export data outside of the EU. The consequence is that we have to be very careful and that we have to be able to account, that's the basis of GDPR, accountability. We have to be able to account for every decision that we take to export data outside of the EU. And if we want to do so, we have to document ourselves. That is the first thing you need to do as a company. Thanks. That's more or less what I wanted to say. Johannes, back to you.
Yeah, thank you. This is actually quite interesting, and I'm pretty sure that this triggers a lot of more questions in this regard, but let me just add one. If you have a client and is using a US provider and you're not able to encrypt, and you did some inventory and research and you're not able to find a comparable provider within the EU, are you advising your client to terminating the contract and look for something else? Does this prevent?
We have to be realistic, I think. It's very hard for a company to drop the software they've been using for many years. So what we are advising our clients at the moment is to assess the situation, do follow-up in 6 months, in 1 year, in 1.5 years, try to evaluate the height of the risk. If it is sensitive data related to a political party or related to medical data, for instance, our advice will be look for a European alternative immediately. If it's contact list and Mailchimp for sending out your newsletters as a pure commercial company, you will probably be able to take the risk for a while longer. But if something goes wrong, you will have to be able to demonstrate that you took all reasonable precautions to prevent any data loss or any data access by third parties. So you will have to document yourself and start looking for an alternative. So the answer is very nuanced. It's not white black. It's there's a lot of shades of gray in the answer to that question.
So it means it's not sure whether it really helps you to protect being fined.
No. The only right answer in GDPR is there is no yes or no. The only real answer is it all depends. It depends on the situation. It depends on you. It depends on the data.
Okay, thank you. I'm sure we can talk about this afterwards again. But let's have a look to the UK. Well, it's already complicated enough, and now Brexit is adding to the mix. Carys, is the UK now an unsafe third country when it comes to data protection?
Well, thank you, Johannes, and hi everybody from the UK. It is a bit of a complicated picture, as you've just said, in the UK now. Next slide, please. As you'll see on the next slide, there are a number of different possibilities as to which law applies, depending on your activities and when the personal data was collected. So we have UK GDPR, EU GDPR, and frozen EU GDPR. UK GDPR is basically the EU GDPR as it was brought into UK law at the end of last year. It applies to personal data processed on or after the 1st of January by businesses with an establishment in the UK, and also to businesses outside the UK who are processing the personal data of anyone in the UK and relating to offering them goods or services or monitoring their behaviour. EU GDPR, as we know, applies to establishments in the EU, but it could apply wider than that if you are your data processing activities fall within its scope. So you're processing the personal data of individuals in the EU related to offering them goods or services or monitoring their behaviour. So for a lot of UK businesses, EU GDPR will continue to apply. for those activities. We also have frozen EU GDPR, which is the EU GDPR as it stood on the 31st of December last year, 2020, and that applies to personal data which UK-based businesses collected before the end of 2020 about people who were located outside the UK at the end of 2020. So all of those different possibilities in which law applies, they're all currently aligned, but we could see differences emerging over time, which could result in the same business having different laws and different requirements applying to different parts of its data processing activities. So it could get a whole lot more complicated for a lot of businesses. It's also worth mentioning that the Schrems II decision of last year does apply and is binding in the UK, because at the time of the decision, EU law applied in the UK. So UK-based businesses cannot get out of the requirements that we're talking about today. But the European Data Protection Board recommendations that Bart mentioned, because they were published in draft form before the end of last year, they're not automatically binding in the UK unless the Information Commissioner in the UK chooses to adopt them, which it hasn't done yet. So next slide, please. That's a bit of a background as to the legal position, but I'm going to look now at what impact that has on data transfer to and from the UK. So as you asked, Johan, are we now a third country? Well, we've been granted a temporary exemption from that status from the EU until the 30th of June this year. So at the moment, there's no additional safeguards needed for transfers of personal data from the EU to the UK. We are also now expecting an EU adequacy decision for the UK to be granted before that temporary exemption expires, because the draft decision has already been published. For our clients who receive personal data from the EU, they're not generally taking any action at the moment, hoping that the adequacy decision is going to be put in place before the exemption expires. But we are advising them to consider, for any business critical transfers of personal data that are taking place, if the relationship is vital or valuable to their business continuity, then we are advising them to put standard contractual clauses in place before the end of June, and also obviously considering whether any additional measures are necessary in addition to standard contractual clauses. That's going to depend on, as Bart has touched on, the sensitivity of the data and the recipient of the data. For data transfers to the UK from other jurisdictions, as before, the local laws of those countries need to be considered. So the position hasn't changed from that perspective, apart from if it's a two-way data exchange and the data is going back from the UK to that country as well, then you'll need to consider whether any additional measures are now needed for that part of the transfer. Next slide, please. So for data transfers into from the UK to the EEA countries, the UK has granted an adequacy decision for all EEA member states, so there's no additional measures needed there. This is going to be kept under review by the UK, although we're not expecting any change to this in the short term. For other jurisdictions, including the US, which we've spoken a lot about already, the UK has also temporarily adopted all existing European Commission adequacy decisions for other jurisdictions. So at the moment, the position in the UK is the same for data transfers out of the EEA that you've just been speaking about, Bart. The risk assessment is slightly different if that's needed, in addition to standard contractual clauses, because the risk assessment is in relation to the data protection rights of individuals in that jurisdiction to assess whether they are equivalent to the rights of individuals in the UK, not equivalent to the rights under the EU GDPR. So that's the slight difference there. Next slide, please. In terms of the UK Information Commissioner, they've actually been really quiet on all of these issues so far. We haven't had much guidance or any clear guidance yet. They've just acknowledged the position and said that they're considering it and will be publishing guidance in due course. What we do know is that the UK is unlikely to adopt the EDPB guidance recommendations following the Schrems II decision, even if those recommendations are formally adopted in the EU. And the UK is also unlikely to adopt the new draft EU standard contractual clauses, which are being considered at the moment. We're expecting instead a new UK version of the standard contractual clauses, which we're hoping will be published sometime this year. And there probably won't be a huge difference to the EU version, especially where the UK adequacy decision hangs in the balance. But the EU standard contractual clauses, which many businesses are probably already using, may cease to be valid in the UK at some point. And as I mentioned earlier, with the different laws applying to different data processing activities, we might reach a position where you need different standard contractual clauses in place for different data processing activities. So where does this leave us in the meantime? Well, not many of our clients are actually taking any action yet. They're waiting for the ICO to make its position known and issue some guidance, some useful guidance. We're advising clients exactly the same as Bart has just been through at the moment, to consider all of their data transfers and focus on the business critical ones at the moment. To use a UK version of the standard contractual clauses, which is available from our Information Commissioner's website, to refer to the correct laws, the UK GDPR now instead of the EU GDPR, and carry out the risk assessment of the recipient and the jurisdiction to see if any other additional measures are needed. So at the moment, we are still following the EU position, but that could diverge. There could be some differences once we receive some guidance from our regulator.
Thank you. This is quite interesting. And it's funny thing is because you said that a lot of UK companies are currently doing nothing in particular, because at least from a German point of view, all the companies who have processes in the UK are currently really trying to sign an SEC. So this is kind of the other way around.
I think that they're banking on the adequacy decision coming. Because it's been published in draft form now, where I think the hope is that that will come into being before the end of June. But as I said, what we are advising our clients is if there is a transfer between the EU and the UK that is critical to your business, then yes, you should be looking at putting standard contractual clauses in place just in case.
Thank you. So let's see where it leads to, and it's still kind of difficult, but that's how it is. So let's have a look to the non-EU countries. Catherine, how does the US respond to the Schrems II decision?
Thank you. So the US had a similar, I mean, it was just as shocking, and the decision also created a good amount of uncertainty in the US as well, with the invalidation of the Privacy Shield. And businesses here have many questions, including, are standard contractual clauses and binding corporate rules enough any longer? What about the Privacy Shield self-certification process that we have here in the US with the Federal Trade Commission, the FTC? What additional safeguards can our businesses put into place that would satisfy these new standards? And how do our businesses respond to transfer impact statements? I would say that there's not a whole lot of clear answers on many of those questions, but I'm going to be speaking with you today about the response, the regulatory response in the US, and then also how our businesses seem to be primarily responding. Next slide, please. So in the US, the regulatory response came pretty quickly from the Department of Commerce, which issued a white paper in September of 2020. This is probably our most substantive response. And the white paper is quite lengthy and goes into some amount of detail as to the importance of the significance of the decision on US businesses and abroad. And it states that when considering the sufficiency of the SEC's, companies should analyze additional information that the Court of Justice of the EU, the CJEU, did not review in the Schrems II decision. And they note, importantly, I think, that there was a limited judicial record that precluded information after July 2016 in the CJEU's analysis of the adequacy of the US laws and protections. So they also note that the CJEU expressly upheld the SEC's, as we've heard from my colleagues today, but there's a caveat that companies are responsible for determining whether US law ensures adequate protections that are afforded under the EU law, including through these additional safeguards. So really, I think what the thrust of the white paper is, and the value, the potential value, is that it offers some relevant information about applicable US law and practice that companies might be able to use in an inquiry by an EU regulator. Further, the white paper actually takes issue with some of the findings, perhaps not surprisingly, of Schrems II. Specifically, they contend that there is sufficient judicial oversight of US intelligence agencies' collection of data under US law, and that such collection is targeted and tailored and subject to review. The EU citizens also have avenues for redress under US law should their information be illegally compromised, and that additional privacy safeguards have been added under US law since July of 2016, all of which would be relevant if in the event or when the question of adequacy comes up for European companies that are transferring data to the US and interested in making that justification of their own business assessment. So the important thing to remember, as with all things, and I think as my colleague Bart said, there is no clear answer, and the white paper is not binding. So its persuasiveness and capacity is essentially untested at this point, but I do think that it will be an important resource for companies moving forward and worth analysis. So the other agency is that we look to is the Federal Trade Commission, which issued a statement from the commissioner. The FTC, the Federal Trade Commission here in the US, is the primary enforcement agency with respect to the Privacy Shield, and before the Privacy Shield, the Safe Harbor. The agency helps ensure that companies communicate honestly with their customers about their privacy and security practices. And their reaction in response to Schrems II is essentially to continue business as usual. The FTC continues to process submissions for self-certification and recertification under the Privacy Shield, which is within the auspice of their authority. And they continue to expect companies to comply with their ongoing obligations if they have self-certified under the Privacy Shield, and they plan to continue enforcement actions for non-compliance. So for companies who are already operating under the Privacy Shield, US companies that are already operating under the Privacy Shield, those protections and enforcement are going to continue. There is also some federal data privacy legislation pending. This has been an ongoing project within the US, and it basically comes down to two stopgap issues. And those are essentially, in a nutshell, whether there should be a private right of action under a federal law, or whether the federal law should preempt state laws, which may be more protective. So that is sort of out there on the horizon. There's certainly a lot of continued interest in it here in the States and a lot of momentum. So we are all hopeful that we'll see some action on it soon, but soon is relative. It could still be a year or more. So next slide, please. I'm just going to speak with you also about the US business response. Again, in a lot of ways, not much has changed. 65% of companies that participate in the Privacy Shield here in the US are small and mid-sized companies, which means these are companies that have limited resources. There obviously, there's the other large company participants, but resources are always an issue with compliance. And the questions they face are, if they are not self-certified with the FTC under the Privacy Shield, should they proceed? It's a voluntary process. And if they have self-certified, the question that some companies are facing are whether or not they should withdraw. Is it worth it to continue to participate? It's worth noting that even if a company were to withdraw, there are continuing obligations on data transfers under the framework, and there's a requirement that you notify your customers of withdrawal. So although some companies are making that, taking that election, not all are, and there's still a little bit of wait and see to see whether or not the EU and US will be able to establish some alternative framework. The other issue are whether or not the standard contractual clauses and BCRs are still applicable, and are they still enough? And I think the answer to that is, in a nutshell, the advice that we give is to still use them, although it's unknown whether they will continue to be considered a valid means of transferring data from the EU to the US, since the real concern that was laid bare under the Schrems II condition was the potential access by US national security agencies. And the SECs could potentially have little to no effect on that, so some experts are doubtful. I would counter that, though, with the information that's contained in the Department of Commerce's white paper, and suggest that we have yet to see and to test whether or not the laws that have been enacted since 2016, and whether the judicial record in Schrems II was even also limited as far as its assessment of laws pre-2016 within the US. So I think it's an open question as to whether or not the laws are actually adequate, and I think that will continue to be an open question until we see some regulatory action. So the other takeaway is, no matter what framework is put in place of the Privacy Shield, certainly one can't imagine the requirements being any lighter. And so we also take into consideration and advising our clients the fact that, if you're already complying with the Privacy Shield and you're already self-certified, you're already on a good path essentially to compliance for whatever additional effort may be needed for, whatever new framework might be established. Additional safeguards, I just want to make a quick note about this. Some of my colleagues have already talked about the encryption and pseudonym of data. But we have a lot of state laws that also require technical and administrative and physical safeguards to be put into place, including in New York and California. And we continue to have our clients follow good privacy hygiene and privacy and data security practices. I also wouldn't underestimate the ability of the private sector to develop tools that will help fill in the meantime and support in the future the gaps that are sort of being created and laid bare through the Schrems II decision, and what additional safeguards may take place. Bart mentioned the fact that currently Mailchimp doesn't have a functionality of enabling EU customers to upload encrypted data. Well, that may change, and that may be a good change that will, impact your own business's assessment on on your ability to transfer data to the US and use services like Mailchimp. And then my last point on responding to transfer impact statements is just that these are coming, and they're coming more frequently. Obviously, I'm sure many of the other attorneys on this call are advising their clients to issue them. There really does not seem to appear yet to be any standard responses. Everything that I've read in terms of assessments on how companies are responding to this and responding to these transfer impact statements is that the responses could range from no response essentially to robust responses that may not necessarily be hit every point, but there's clearly effort there. And that's essentially what we advise our clients to do when we receive those transfer impact statements. So with that, I'll hand it back over to yours, or Johannes.
Yeah, thank you. Cool. I have one question, because in the EU, the California Consumer Privacy Act was quite, well discussed and noticed, and it seems that it is a little bit, well, comparable to the GDPR. So do you think for a, let's say, a European-based company, is it better to have a provider who is in California because of data subject rights or something like this, or it doesn't?
I would actually suggest that it doesn't need to only be a company that is based in California. Rather, the question might be whether it's a company that is subject to CCPA, because there are many companies all over the country that would be subject to CCPA and therefore, have to be in compliance with that law and the accompanying regulations. So that may open, if there's an assessment, I think the assessment, it seems clear, needs to be done by the EU company making the data transfer. If the assessment by that company is that the US laws are in fact protective enough, then, taking into account the somewhat comparable nature of CCPA to GDPR may help with that analysis. I'll caveat that by saying I don't think it would address the issue with FISA, because that and therefore U.S. national security agencies' access to or ability to access personal information, because that would preempt the state law as a federal law. But counter that again with the ammunition, let's say, that was provided in the Department of Commerce white paper around all of the safeguards and checks and balances that exist on the exercise of that authority by under FISA, and the ability and redress of not just US citizens, but also EU individuals who may feel that their information was wrongfully accessed through any of those legal frameworks. And the white paper, we can include a link to that here and send that out. But it is very helpful. It's very thorough, and it's a very useful document to give an idea of what other, for example, individual redress some folks may have if they felt in the adequacy of the protections and checks and balances.
Cool. Yeah, thank you. So let's jump over to India, Yanak. How does India has a GDPR comparable Privacy Act or something like this? And how is the Schrems II decision affected the companies in India?
Thank you, Johannes, and thank you, Catherine. So the present legal framework governing data protection in India is limited, in the sense that the existing Information Technology Act has two sections which essentially govern data protection. The section 43A, as you can see on your screen, deals with compensation for failure to protect data. Section 72A, which deals with punishment for disclosure of information in breach of a lawful contract. These are the two sections which presently govern data protection regime in India. The good thing, however, is that a Personal Data Protection Bill 2019 was introduced in the lower house of the Parliament. It was referred to a joint parliamentary committee of both the houses. In fact, most of the big tech companies, the Microsofts, the Facebooks, the Truecallers of the world have represented before this committee, joint parliamentary committee, and given their suggestions. The draft bill as it stands today is to a certain extent comparable to the EU GDPR regulations. There are some aspects of it which are of particular concern, for example, storage of data within India, aspects which are not yet defined, what is critical personal data, what is sensitive personal data. But in the course of the time, by the time the bill becomes a law, which we expect that will happen in 2021, there should be reasonable protection that should be available in terms of the legal framework. But if the question is whether the Indian government will be restricted from accessing that data, I think then that same issue will always remain, in the sense that for national security, for sovereignty, the government obviously has retained all the rights and controls to make sure that they can access the data, but following the proper safeguards. So we do expect that sooner or later India would be treated as an adequate country. But at this point of time, all the businesses have kind of entered into standard contractual clauses with their counterparts in Europe, and business is going on. As you would know, India is one of the leading software outsourcing and service provider country. It's also one of the leading pharmaceutical manufacturers, or for that matter, clinical trial countries. A lot of pharmaceutical and international research which deals with actual clinical trials does happen in India, and a lot of personal data is transferred. So while standard contractual clauses are signed and scribbled upon, as Juris mentioned in the beginning, which is pretty interesting, it sometimes does happen in that manner. But at the same time, there is now some level of awareness of at least GDPR, if not the Schrems II judgment. Schrems II is something that is now gradually percolating. One of this session is one of those events which further percolates the outcome of Schrems II to Indian businesses and companies. In terms of the action steps that we are generally suggesting our clients to take is, if there are two buckets of this. One is data which has already been transferred or is ongoing in terms of transfer, in terms of existing contracts, and one is new contracts which would be entered into. As far as existing contracts are concerned, since there are standard contractual clauses already in place, it's only when, say, a European counterpart demands certain additional aspects to do further diligence based on a Schrems II judgment, where that's when the cycle is initiated. But when it is in fact initiated, the problem comes that almost all Indian companies do use American softwares. For example, you would use Microsoft tools, they would use AWS. And with this whole Schrems II aspect now creating that uncertainty, there's a lot of rework which kind of needs to be done. Now, for example, Microsoft itself, even as on today, mentions on its website that as far as data from Europe is concerned, it does comply with the privacy shield. Though it does not rely upon it, it will comply with all the norms of the GDPR regulations. But it does not mention the same for Indian entities. But what about a situation where there is European data which is there in India, which is being used, which is being supplied to American software? Now, that situation is not yet being factored even by someone, say, a Microsoft. But then only when you insist upon it is when those kinds of things, are additional protections are granted by the software providers. Whether there's a cost increase, definitely there is an additional cost increase, because something that was already closed, done and dusted now needs to be reopened and reassessed. But whether it is being seen as an opportunity or a burden, I think businesses in India are kind of seeing it as an opportunity, considering that India, first of all, is a democracy. If the European government cannot, say, trust the American government in terms of the access to data, it is much likely to trust any other competitor country which is not a democracy, for example. So from that perspective, it is looked upon as an opportunity by Indian businesses, and we do hope that sooner or later India would be treated as an adequate country. And India has a significant amount of data. Definitely, it has 1.3 billion people, and at one point of time, sooner or later, India expects that European Union definitely would want to treat India as an adequate country. Thank you, Johannes. Back to you. And I think I leave you with the most important slide, and maybe you can go to the next slide. Thank you.
Thank you, Yanak, and we're really looking forward to have an India-EU privacy shield, something like this, soon in future. This would really help. Well, thanks a lot for all of you, and I would now open the Q&A session. Are there any questions? If not, I do have some. So you're free to ask, to put something in. I saw there were already some questions in the chat and they were already answered. If not, let me know. Otherwise, let me just, yeah. Okay, let's see, we have one. At Yanak for India, you can see it, right? How far in the future, 2025, could we expect a privacy shield or adequacy decision?
So as I said, the data protection law is going to come into force in 2021. That itself should give enough protection. I believe as good as a privacy shield possibly, if the companies do comply with it. Maybe that could be a starting point, but I'm sure adequacy decisions take time, and I don't think it will take as long as 2025, but at least I would think a 2022 by the time we have something like a privacy shield or an adequacy decision.
Thank you. So I'm wondering, as you probably know, there will be a new set of SCCs soon. Will this help to solve this Schrems issue, or is this only one little piece and not the, let's say, answer for all the trouble we got?
From the UK perspective, Johan, as I think I mentioned in my presentation, it's unlikely that the UK is going to adopt those new SCCs. So I think that's going to be an added complication where the UK is involved.
Yeah. And from an EU perspective, and in a first stage, those new SECs risk to complicate things because companies will have to start replacing the existing SECs with the new ones. That in itself will be quite a lot of work for some companies. But it will be a major part in the puzzle, and it's given the fact that the new SECs will incorporate a series of additional measures, additional safeguards that can be implemented or that should be implemented. So they will already contain, on a contractual basis, a lot of the things that now have to be done by the companies themselves or on their own initiative. So it will help, I guess.
What's your point of view? Do companies really have to change or have to sign the new ones, or is it just an option and you can still use like the current one, the old ones?
Yeah, interesting question. I'd like to hear the opinion of the others. As far as I see it, since the SACs are standard contract clauses that have to be copy-pasted literally, there's no room for maneuver, no room for changes. If there are new SACs, you will have to use new ones.
I think at least from the German point of view, I would also advise my clients to sign the new ones because they're probably better than the other ones. But on the other hand, there are data protection authorities which, said it's good to add the current standard contractual clauses by specific safeguards to be, let's say, at least more in compliance with the Schrems II requirements than before. But we'll see. So I want to raise another question, or let's say a problem, which is sub-processes, because, well, even though my contractual partner is within the EU, which is from the first point of view, then I'm all fine and I have nothing to be aware of Schrems II. But what happens if the sub-processor of my of my provider is placed in the US? How are we going to handle this situation?
Silence everywhere. First, to add to your questions, how do I know that a sub-processor is in the US? Because from what we've been seeing, and we've done a comparison of 10 to 15 major software tools in the marketing world, marketing automation tools, CRM tools. For most of them, it's unclear, almost impossible to know what sub-processors they're using and where they are located and what data they're sharing with those sub-processors. So the first question is, how do I know?
Yeah, that's quite. This is where your Q&A formula is taking place, and what I'm actually doing is a lot of just advise companies to really get to your providers and ask them what's their setup, what are their sub-processors, and then from there take it from there and evaluate what to do and what we have to sign additional safeguards or not. So
Johannes, there is another question.
Okay.
From somebody who's asking, as the current EU SCCs don't cover processor controller provision, is it worth incorporating in the draft new SCC which do contain those provision for the time being?
Well, from my point of view, this is nothing what is really necessary. We just need to try to get these additional safeguards, but this is not the point. I really appreciate that there will be something like a processor situation with the new SCCs, but at least from my point of view, for the time being, it's nothing which we necessarily need to add in the current SCC, from my point of view. I don't know, what do you think?
Since the new ones will be there very soon now, there's really no use in doing something provisional just to cover the period of a few weeks, a few months at max. That still needs to be covered. Just wait for the new versions and put everything in place the right way from the first time at that moment.
Yes, I agree with you to that, Bart.
So I would maybe once again get back to the Mailchimp decision, because this is what a lot of people will affect. And yeah, it says more or less that you should stop using this. And I'm just wondering whether this is really serious, or I don't know, are you guys advising your client to stop using Mailchimp, or is there maybe something where, you could either say you just have to be aware that you might stop using it?
Maybe let's start with Bart, yes?
I'm almost afraid to say that we use Mailchimp ourselves. As a matter of by way of example, we have decided to abandon Mailchimp and to look for an EU alternative, which we will be implementing in 2 or 3 weeks. Now, the Bavarian decision does not render Mailchimp as a company or as a tool illegal. That's not what the Bavarian DPA said. If, as a company, you can justify that the data you are sharing with Mailchimp is not very sensitive, there is no real risk involved, you have taken all the precautions you can possibly take, then probably you can continue to use it. But again, if you are one of our clients, 2 of our clients are trade unions, one of them is a political party. For those 3 clients, we would advise to drop Mailchimp immediately, because they are sharing sensitive political related data outside of the EU. In other contexts, you can probably continue to use it. the most important thing, as always, under GDPR, document yourself, make sure you have a valid justification, explanation, be able to justify yourself, and then we would advise clients not to drop immediately. Mailchimp is probably not the biggest issue. I think there are bigger issues. Most CRM tools, look at always dangerous to mention companies, but the data you share with Google, with Facebook, with Microsoft is a lot more, you share a lot more data with them that is potentially a lot more sensitive and that has a bigger impact than a mailing list in Mailchimp, I would say. So Mailchimp is probably not the biggest issue, and not everybody should depend on Mailchimp.
I've got a question here. Are you using Sending Blue instead of Mailchimp? I don't know, Sending Blue, but
we are in the midst of digitalization of our firm on different levels. One of the things we are doing is implementing a marketing automation strategy, and with a partner that's doing that for us, we have decided to move to ActiveCampaign for a number of reasons that are not even directly related to Mailchimp. But I think that what we are doing and the tools we are using are not very relevant to to the discussion.
I think one point is worth to mention that the German Data Protection Authority, who issued this decision, they also said it not generally not stopped using Mailchimp, but also that this company did not do the right inventory and did not check whether there might be other providers and other maybe EU-based providers for this kind of service. So I don't know how they would have decided if they would have done precise and diligent inventory, but at least this was one point which was mentioned, and other data protection authorities in Germany already said that no, if they're not very sensitive data, you can still use US-based basis.
To add to that, Johannes, I always think that I already said it in the chats earlier, the main risk I fear is data breaches. If we see the number of data breaches over the past few weeks with Facebook, with Clubhouse, with other big companies in the US, the Schrems II decision is not only on government access by US authorities, it's about unwanted or involuntary access to your data in general. If at some point Mailchimp is hacked in the US and a few millions, tens of millions of people's personal data are on the streets, and it turns out that you did not take appropriate measures and you did not document yourself, as you said was the case for the German company in that case, the fine you will run into as a data controller will be exponentially higher than in the cases where you can demonstrate that you took all possible precautions to prevent loss of data with Mailchimp or any other provider in that game, for that matter. That's my biggest fear for my clients. Data.
Yeah, I'd agree with that, Bart. And I think the other risk there is that your non-compliance, if you decide not to change, is probably unlikely to come to light to the authorities unless there is a data breach. So the data breach itself will bring your non-compliance to light to them.
Yeah, I think just to follow up on what Bart is saying, we would, the paper trail is key, isn't it? And like possibly a TPIA, that you can have done and then put in the drawer. And in the event of a breach, then the Data Protection Commission comes talking, and you say, well, we've mitigated. Look, we thought about it. We've mitigated as much as we possibly could. So if you're going to fine us, please make it small.
What I never really understood is in this whole issue of Schrems II is that, as you mentioned, Bart, already, that there is a distinction between, well, what you request from, let's say, Microsoft and what you request from smaller providers like Mailchimp or other providers situated outside the EU. And I'm just wondering, well, if the authorities would take this decision really, really serious, we're not even able to use any provider outside the EU and no sub-processor outside the EU. And I'm wondering whether, there are a lot of EU authorities and German data protection authorities who are actually using Microsoft Office 365. So I'm wondering whether this affects their decisions on where to, put the fines and where not to. And I'm really curious where this leads us to.
Johannes, can I add something? Because I think that we might see a Schrems III since there is a new action against Google Android. I think for illegally tracking the use. That will be even more complicated if there is a Schrems II.
There is a noise. I did not get the question right, I guess.
My question is, what do you think that there will be a Schrems III coming in, as they started now an action against Google because of the Android system?
Well, Schrems III, well, I'm sure there will be some further actions in this regard. I just heard yesterday that at least Hamburg Data Protection Authority filed a new action against Google and it's Facebook and WhatsApp in Ireland. So I do think that there will come up a lot of new decisions in this regard in future. So yeah, it's probably not a Schrems III, but well, they're all kind of based on this Schrems II decision, I guess.
What is interesting is that the entire system of contract clauses as binding corporate rules is based on the same starting point as the Privacy Shield before. It's a contractual or a legislative promise by the receiving party that your data will be safe. But if US companies can't guarantee that your data is safe under Privacy Shield, there's no way they can do it on a contextual basis. So any attack by Max Schrems, for instance, on the standard contract clauses, by nature should have the same consequences as the Schrems II decision, and that would be a Schrems III. But that's interesting to see if things will go that way or not.
Just to add to that, it's also to be seen if other adequacy decisions for other countries, such as Argentina or Japan, will also hold if someone files a complaint. Because, for example, the adequacy decision of the European Commission of Japan is like, I think, like 30 pages, but the adequate decision for Argentina is much, much shorter. So it's also to be seen if there's a complaint, if these adequate countries will stay adequate.
Yeah. So we are already, let's say, 25 minutes over our actually schedule. So I would say if there are no any further questions, I would hand over to Caroline to close this webinar, and I would like to thank everybody for joining. It was a pleasure from my side, and yeah, I really hope to see you soon somewhere in live at any Consulegis event or anywhere else.
Thank you so much, Johannes, for having moderated, and thank you for all the speakers today and all the participants who have joined. You will receive a link to the recording of this session, as well as obviously the presentation. And thank you all. Obviously, we will be doing much more other events and other webinars. And if you want to follow up or get in touch with any of the participants or any of the speaker, you will have their emails in the email. And thank you. And we are very pleased, and see you next time. And bye-bye.